Author, columnist, managing editor of LibertyNation.com, podcast host and conservative policy advocate.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
The United States Supreme Court is due to begin its session of deliberations in just a few days. And with that comes the possibility of constitutional strengthening or weakening. Welcome back to Liberty Nation Radio, heard coast to coast on the Radio America Network. I'm your host, Mark Angelides. On today's special edition, we'll examine the composition of the court, the political leanings, what the big cases are that are coming up, and what the implications these cases will have for the future of America. Now, remember, this show is proudly sponsored by LibertyNation.com. You can access podcasts, breaking news, analysis, and a range of biting and brilliant shows to whet your appetite for freedom and your fondness for the great American Constitution. And you're listening to Liberty Nation Radio here on the Radio America Network. We are having a Supreme Court special today with Liberty Nation's legal affairs editor, Mr. Scott DeCosenza, host of the excellent Uprising podcast, and a Supreme Court watcher of the first degree. And we'll be talking about the court docket that's coming up for this year involving the Chevron defense, social media state actions, First Amendment, Second Amendment, of course, the appropriations clause, public figures via criticism, public figures via trademarks, bankruptcy, opioid liability, race in redistricting, and just about every fantastic piece of jurisprudence you can shake a stick at, as we say. Scott, thanks for being here.
Going hard in the paint, Mark, as we say.
Now, Scott, there are some big cases coming up over the next term, which kicks off on October 2nd. Which ones are you particularly interested in following?
Well, there's two that are the big boys on the block for me. I expect that it could be a very big term, probably not as big as recent past terms with abortion and guns, but nevertheless, the first one up has blockbuster potential, and the issue is called the Chevron deference. Right. For people when they kind of see that headline in the news, and the case name is Loper Bright Enterprises v. Raimondo. But Chevron deference refers to a case title named Chevron. I think it's from 84, maybe 85, when the Supreme Court made a rule where they said they were going to, and then lower federal courts should give deference to federal government agency interpretation of laws and regulations. And so what this means is...
Let's break that down just so it's very, very clear, please, what that actually means in practice.
So what it means is you are Harry homeowner and you've got a back 40 of land somewhere in the United States, and you want to build a retaining wall or pond to contain liquid or who knows what, any manner of things. But there's some regulation that says like that is a Water Act regulation, and the regulators have put forth rules, and maybe it's the EPA or maybe it's the Bureau of Land Management or somebody that puts forth some rule that says you can't build on this because it impacts navigable waterways because of the way the rain flows or something like that. Now, if you read the law, it will very seldom point to that behavior or act being forbidden. Lawmakers
wouldn't say
do that.
You can't build a pond. It will have
regulators did
scope.
it. Yeah. Regulators did it. And so the people then go to court and they say, I want to build on my back 40. And the regulators say, oh, you can't because the regulation prohibits it. And the regulation itself is vague or unclear about it. Well, what should happen? Well, for those of us who celebrate the founder's vision of limited government and liberty for the people, Mark, say the person should be able to build unless the rule explicitly forbids it, because that's what freedom and private property are all about. The current rule is,
under the Chevron deference.
Under the Chevron deference, again, the original case name is Chevron, so the court will give deference to the federal government agency interpretation of those regulations. And, it's not a get-out-of-jail-free card for the agencies. They still have to have some, regulation of at least a fig leaf they can put behind their wanton wishes, but it's definitely not a sort of pro-liberty perspective from the courts. And this is very much a case that falls along ideological lines. The people who are advocates and in favor of limited government are bursting at the seams for Chevron deference to go away. We think it is a horribly decided precedent that has just given and breathed life into petty tyrants and dictators to control what the American people are doing, and that the progressive legal minds often are vigorously opposed to it. because it would really restrict the ability of many kind of regulations that are on the fence to go forward, because there's not the will, of course, to really do, to implement the most odious or restrictive interpretations of those regulations and actually put them into black and white.
So it seems to me that because of the Chevron defense, the danger that's posed,
deference, right?
The danger that's posed and has likely actually happened since 1984 when this first came in is that essentially laws are made up by the administrating agencies that are not written down as laws as such. But for example, to use your example, the guy with the back 40, the law now states, because of the Chevron deference, that you can't build a pond, whereas you can't build a pond was never in the law as it was enacted, right?
That's right. Yeah, and you'll hear it as Raimondo and the Chevron deference cases, and I think that it is, if the Supreme Court overturns its previous decision in Chevron and says that there shall be no deference, I think that'll be the biggest case to come out of this term. I don't think we're going to see what I would hope, which would be that the justices would say we should have deference to the citizen against the government. That's the way. There's a notion in the civil law, Mark, which is that in the United States that vagaries or ambiguities in the construction of a legal agreement shall be charged against the party that drafted it. So if you and I are engaged in some sale of goods and I'm selling you the goods and I draft a contract and you sell it and it's vague on who should pay for the delivery, well, I drafted the document, and on our legal system, I'm likely to be held as the person who should have done a better job because I'm the one who had all the power to draft it. And we could see a rule like that. I don't think it's ever going to happen, but boy, wouldn't that be a nice change? Instead of saying, hey, we'll just go with what the federal government bureaucrats say, let's go with what the people think.
It's an interesting and wonderful prospect. But if they do rule against low propriety enterprises and in favor of Raimondo, the Supreme Court, obviously, I mean, it's not likely to be what you call a bright line ruling. You think it's going to be something a little more softer, but perhaps ending the Chevron deference to some degree.
We'll see. These are a cagey group.
It's just that I find it hard to see how such a decision could be nuanced, if you understand my meaning.
Well, wait and see how it comes out, and you'll see how it can be nuanced, Mark.
The
court has an amazing way. And well, here one of the ways it can be nuanced for sure is that we can see many different opinions, even by people who agree with the outcome of that opinion. This group of justices has been very much independently minded, and we've seen a lot of cases where they agree on the outcome, but not necessarily the reasoning how to get there and what it means going forward. So I would suspect that, if I was making a prediction, I would predict that they do away with the Chevron deference without creating what you and I would think of as a bright line rule, and there will be murkiness ahead. That's sort of, I think, how these rules have been going on, which is that there's a willingness to break down landmark rules that were kind of established by lefty courts and progressive theories of the law, but not then implement in their stead a kind of robust and conservative bright line, but instead sort of sort out some path forward that is absent that bright line.
So we're not looking for a Savonarola bonfire of the vanities in terms of the regulations, but I wonder what the political pushback would be if the court does rule against the Chevron deference, because I can't see anybody with a straight face and hoping to get re-elected on either side of the aisle saying, well, you know what we need to do is give more regulation to government agencies, even when they're vague and can be used punitively.
That's not how they'll sell their outrage, Mark. Elizabeth Warren will be on all the newscasts shaking her fist and talking about how this is so fat cats can evict old ladies or something like that. There'll be, who knows what the human interest angle will be, but it will be oppression versus versus righteousness, to be sure. Not let's encourage vague and onerous regulations upon the people without redress. So
a rose by any other name. We'll be back with Scott Dickerson discussing both the First and Second Amendment after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And we're back with Scott Dickerson discussing the big cases at the Supreme Court in the session that starts on October 2nd this year. Now, Scott, I want to talk the Second Amendment case just because I love the Second Amendment. You love the Second Amendment. We all love the Second Amendment. Can I get a hallelujah? Scott, there's a Second Amendment case in the Supreme Court. What are the details on that?
Well, I think we especially love the more recent interpretation of the Second Amendment by the United States Supreme Court, that it does in fact protect us from all manner of imposition by state and local officials and federal officials to boot. The case is U.S. v. Rahimi, is the big Second Amendment case so far at the Supreme Court. We should add in our discussion of the Supreme Court, Mark, that they don't just set their cases before the first argument and then run with those. They are on a rolling basis accepting cases. So our preview only includes the cases they have already agreed to hear, and there will be more of all sorts we expect. But U.S. v. Rahimi is the big Second Amendment case, and it talks about the domestic violence restraining order prohibition on having guns if you are subject to one of those orders. This was a feature of the Violence Against Women Act, I believe, federal legislation. And what it did was it said that any person in America who is subject to one of these domestic violence restraining orders, it's illegal for them to have a gun. They have to take all their guns immediately to some authorized party, whether that's a gun dealer or somebody else, and extinguish their possession of them. There's mechanisms in the law for them to kind of recover their rights, but the problem, Mark, is, and I have some expertise here because my first job as a lawyer was actually practicing in the domestic violence courts, and I have sought and gotten domestic violence restraining orders placed against people. And the level of respect for their fundamental rights that could be abridged by those orders is almost none in the courts. So what I'm suggesting is I have been a participant in the mechanism that removes these rights from people, not because I intended to do so as a function of their constitutional rights, but just simply on the domestic violence protection side. And what happens is judges are oftentimes loath to deny women domestic violence protection orders because they see the cost as minimal to the spouse or domestic partner, and the safety benefit is great, and they don't want to be the judge who said no, and then the guy goes and
shoots his
hurts
wife
or kills.
Yeah,
exactly. And they're the judge who said no. So they often grant them. And oftentimes, this was my experience as a lawyer, is that oftentimes these people, and almost always men, there are some women who are subject to these orders, but almost always we're talking about men, and they very often don't have lawyers. They are people who don't have a lot of resources. They're not going to go spend thousands of dollars to make sure all their rights are protected when they don't even know necessarily that this kind of order would affect their rights forever, meaning, it has lifelong potential implications. So the idea that this may violate the Second Amendment is far from kind of out there, Mark. The recent Bruin case clarified that the Second Amendment, I think, really means what it says. It was lauded by me and I think so many other gun rights proponents because it breathed life into the Second Amendment. Your intro talked about that we love the Second Amendment. Well, we only love it if it means something. If it doesn't mean a damn thing and they can take away your guns for any reason, well, then what's to love? But if it means that the people have the right to keep and bear arms, absent some demonstrated violation of that, what would give us our rights.
So what is Rahimi claiming in this case that an order was placed against him, and that removed his
Mr.
rights.
Rahimi,
and now
by the way,
it's
seems to be a real bad hombre, and many of our laws
Right.
are decided not by the best examples of human
Sure.
behavior. So let's not hold up him as a
Sure.
stellar human being. By all manners, he seems to not be a stellar human being, but also he's a human being with constitutional rights. And if
Yeah.
we don't uphold his constitutional rights, then we're upholding none of ours in some meaningful capacity. And so basically what he's saying is he was subject to this restraining order. He was found with a gun. They prosecuted him for having a firearm in violation of federal law, which says if you're subject to a domestic violence restraining order, you may not possess a firearm. He did, and he was subject to federal criminal prosecution for that. He was convicted and sentenced to prison. And he says I should have this conviction lifted from me because it violates my Second Amendment right, because the mere imposition of that restraining order can't legally trigger a violation of my Second Amendment rights.
Okay. I mean, that's going to be an interesting case. Obviously, with this, we have no idea which side this is going to land.
Well, if we have a minute, I'd like to talk about the procedural part of that. I think there's some interesting information to be revealed by it. Currently, the Fifth Circuit Court of Appeals said that the government's actions were violative of Mr. Rahimi's rights. He currently sits as somebody who the disposition of his case is they said he should basically walk from those charges. Now, that's all kind of in abeyance while the Supreme Court takes the case. But the Fifth Circuit U.S. Court of Appeals is the most conservative court by a long shot in our country, and it's turning out
the anti-Ninth Circuit, right?
That's how I think about it often. The Ninth Circuit Court of Appeals being historically the most liberal and often kind of extravagantly so with some of their interpretations of the law. And we're now seeing some of that on the Fifth Circuit. It's kind of amusing in some sense. Some of their from my perspective, going a little bit off the deep end on the conservative side. But so this court said 4 justices voted to take this case. Now, it could be 4 liberals voted because they want to take the case to clarify that it's still good law. And maybe they think that they can, when they count votes, that one of the conservatives will sort of lean their way. Or maybe the conservatives or the court wants to clarify through the Rahimi case what it meant in the Bruen case. We've seen all manner of lower courts wrestling with Bruen, notably in jurisdictions that are hostile to gun rights, and whether it's New York or New Jersey authorities or California authorities, wishing and wanting that the Bruen case didn't exist and trying to legislate seemingly around it or through it. And so the Supreme Court, I think, has a bunch of work to do in cleaning up its legacy of Bruen and what it means by that. And this may be, part of the long future history of that work.
So either way, this case is looking to be almost a lens which will clarify or refocus what was stated in Bruen, or clarify and refocus the domestic violence restraining orders. It does mean what it says on the tin, as we often say.
Or break your heart by doing none of the above, Mark. I always say that if you expect to be disappointed by the Supreme Court, then your expectations will probably be met.
All right, Scott D. Cosenza, thanks ever so much for being with us today.
Thank you, Mark.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
On October 2nd, the Supreme Court resumes, and with it, all the fun of the fair. Now, the court docket already includes some significant cases involving the Chevron defense, social media, state action, and the First Amendment. Questions of criticism of public figures via trademarks, domestic violence, Second Amendment case, appropriation clause, bankruptcy, and the opioid liability. And of course, let's not forget some race cases. Now, who better to discuss all of this massive legal fanfare than Mr. Scott D. Cosenza, Liberty Nation's legal affairs editor, host of the excellent Uprising podcast, which you can check out on the pages of libertynation.com and all good podcast providers. Scott D. Cosenza, Esquire, welcome back to the show.
Thank you so much, Mark. And I have participated in the audience of a Supreme Court argument, too. I'll have you know that as well.
Well, I mean, that basically qualifies you more than Twitter. Which is sorry, I should not dead name social media companies anymore. X, right? It's X
At Podcast Uprising.
at Podcast Uprising to go and check out Scott's wonderful content. Always biting, always witty, and occasionally saucy. Not in that way. So, Scott, let's make a start on our special Supreme Court edition and talk about the court politics and composition. Your thoughts?
Yes, well, we're told by the legacy media, Mark, that the people want a Supreme Court ethics, the imposition of some ethics standard upon the Supreme Court. This is all in reference to the attacks on Justice Thomas and the way we see, I think, capture by the left of all manner of regulatory bodies. It makes sense for them to try to impose regulatory capture and processes on all manner of things, because who's going to control them, right?
Absolutely. Well, let's delve onto that. Let's dig into that ever so briefly, Scott, because we have, at the moment, you've got a Democrat-led Senate, you've got a Democrat in the White House. Now, I think, there's this whole thing, a deal that I would take. Now, I reckon that the Republican half of the country, or the more conservative or libertarian half of the country, maybe not the libertarians, but I reckon that the Republican half of the country would accept a revamping of an ethics, or a creation of an ethics board or panel or a set of strictures if they were allowed to do it. And what do you think about that? So let's say Democrats say we need an ethics code of conduct. And Republicans say, okay, sure, but we get to write it. Do you think they'd go for that deal?
Many Republican voters, I think, would go for that deal. I think it's ill-advised, though.
It is, isn't it? It's short-term thinking. But which brings us back to the point of the original. The Democrats are going for that now, and it's short-term thinking to let them go ahead with that.
Well, I would argue against it on multiple fronts, but my chief argument against it, and it's one that we don't hear many people making the case for, is that it's totally and completely unconstitutional, and it violates the constitutional strictures of separation of powers. What we have is that sort of in terms of leading politicians in the Senate, Dick Durbin, chairman of the Senate Judiciary Committee, and Chuck Schumer, I think is the former chairman of that committee and now leader of the Senate. He or they have tried to impose their will as legislators with their preferences upon the Supreme Court. And when they say they want the imposition of this board, it's through legislation that the Congress drafts and passes and the president signs. So that would be two branches of government colluding to impose burdens on a third branch, which is something we don't allow in our system. So, for instance, Mark, I just want people to think about it this way. Let's say that United States Chief Justice of the United States, John Roberts, and Chuck Schumer decided that Joe Biden should have to do certain things. So they just got together and said that this should happen and imposed some kind of, decree upon the president. Well, that's not what our Constitution says. And all these different institutions, their operating rules, they come from the United States Constitution, not from federal law, not from regulations passed by Congress or wished into being, by the people.
Yeah, so, I mean, it's the idea that they are three separate co-equal branches of government. And if one could legislate over the other, then it's no longer a co-equal branch, which kind of upsets the whole. It's like, imagine it's a three-legged stool and one leg's shorter than the other. You're going to fall off, right?
The court would be totally neutered if they allowed the Congress to impose these requirements on them.
And the thing is, what's really leading this, from what I can tell, is, as you say, it's that it's using accusations against Justice Clarence Thomas and his friendship with, I believe it's Harlan Crow, Mr. Harlan Crow, a billionaire, and his relationship, even though there has been no laws broken, there's been no, as far as we know, like unethical gifts, that he's done nothing outside of what is normal practice for two lifelong friends. And yet people are ignoring the far more questionable scandals of Justice Sonia Sotomayor and having her taxpayer staff within the court selling her books. That's
So
not
there's lots to unpack there. Let's talk for a moment about Justice Thomas. He at the end of the summer filed an amended disclosure report. There were new regulations put forth by the U.S. Judicial Conference, which all of the United States Supreme Court justices have said they will voluntarily adhere themselves to those practices. And that, by the way, is the best practice for the court, which is to say that people deserve and demand transparency with certain aspects of the lives of the public officials, especially and including the Supreme Court. And it's great that the Supreme Court doesn't force the issue with trying to get us to, I think, what would be the appropriate way to impose new rules on them, which would be to amend the Constitution. And that's a fairly drastic act. So to the extent that the justices say, we will abide by these disclosure requirements and then do abide by them, we should, I think, celebrate that and just run with that as how we go. And that's what Justice Thomas filed pursuant to the new rules and regulations. And we learned a lot about his affairs with Mr. Crow. Now, I want to take issue with one thing that you said, which was that none of those transactions or dealings were kind of out of the ordinary that a normal person might have with another person. For most of those things, it's true, meaning if you're friends with somebody who is, middle class or lower class, and you go on vacations with them, it would be expected maybe that you would go to venues that you would ordinarily attend if you were in that class that financial class of being. Yeah. So the restaurants that you went to, the mode of travel that you did, they would all be sort of a kind. And also that would change if you happen to be friends with a billionaire like Mr. Crow is. Okay. So
sure. No Buc-ee's in an RV. Gotcha.
That's like that. Well, it's funny because Justice Thomas is famously known for
he
loving
is famous for his RV.
But you're right. But not a broke down, nasty RV, a nice RV. But there are some transactions, namely that Mr. Crow purchased Justice Thomas's mother's home and property that Justice Thomas also had a financial interest in. So now that alone doesn't mean that it's scandalous, right? But it is a kind of, what's going on there? Now, according to Justice Thomas and according to Harlan Crow, what's going on there is he wishes to venerate Justice Thomas and his legacy. And so he actually purchased the property with a mind towards, making it I don't want to say tourist attraction because those aren't words that he used, but something along the lines of preserving it because of his, veneration of Justice Thomas. Now that's a little bit, outside the ordinary, but as long as Justice Thomas isn't weighing in on Harlan Crow's affairs as a justice, right? Whether sure. He's, ruling on things that directly affect Mr. Crow, then I think it stands to reason that this is, within the bounds of acceptable conduct. And if it's not, at least it's been disclosed. So now those who oppose Justice Thomas, if they wish to move to impeach him, they can do so on the facts. But it's also, one of the things that's an incumbent to say, I think, if we want to say that, for instance, Durbin has been, I think, Justice Thomas's chief, within the leadership, his biggest criticism, hosting these hearings that are poised at fact-finding, that critics of them might say we're not fact-finding at all, but just dressed up to attack justices on the right, and Justice Thomas specifically is, if you are, if the groups amassed against Justice Thomas are amassed against him because of his the political ramifications of his jurisprudence and hate him and want to destroy him because of that, and really don't care about the judicial ethics of the situation, but they're just using that to not give a nod to that and understand it. In other words, we need Justice Thomas and all justices to abide by a high level of ethical standard, okay? And so it's important if somebody brings forward allegations that somebody didn't, that we address those allegations. And it's also important to recognize if all the people that are making those allegations really don't care about any of it and they're just out to get Justice Thomas, which they've said those words directly in print. It's important to recognize that too. So I want to kind of play both sides of that and recognize that, I don't think it's odd that somebody raises an eyebrow that Harlan Crow bought Justice Thomas's mom's, homestead. And also They don't care about that. All they care about is abortion and guns and other issues and the way that Justice Thomas votes on.
We'll be back talking Justice Thomas and the other justices and the left's attacks and the right attacks later on in the show after this short break. Don't go anywhere. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And we're back here on Liberty Nation Radio, continuing our discussion on the Supreme Court, the new term, and specifically what we've just finished talking about in the first segment, and now carrying on this discussion, the composition of the court, the attacks from the right and the left, and what's likely to happen to the court going forward. And we're joined once again by Scott D. Cosenza, Liberty Nation's legal affairs editor, host of the excellent Uprising podcast, and a self-admitted, once attended an actual Supreme Court deliberation. Thanks for being back here, Scott.
More than once, even.
Wow, well done. That makes you like a season ticket holder to the Supreme Court.
I wish.
We just finished talking about the numerous accusations, situation Justice Clarence Thomas finds himself in. But let's spread this out a little bit further. We see a lot of calls for an expansion of the Supreme Court. Now, again, this kind of brings me back to the very first point we made in the show today. If the left is the group calling for an expansion of the Supreme Court now, presumably and quite obviously, because they want to dilute the conservative branch, which is in the majority at present.
Mark, just because every single one of these calls to expand the court happened after conservatives started winning cases, how dare you suggest that this is some outcome-based effort on behalf of those lefty legal scholars?
Scott, I dare. I'll even tell you in Chinese.
What other evidence is there to suggest that they're motivated by the outcome of cases rather than...
Let's go back to the deal would you take, Scott? Let's go back to that. So let's say Democrats propose, let's expand the court by 4 or 5. And then they make the deal. They say, and we'll do that, and the Republicans can choose the justices. Does that go ahead? Yes or no? It doesn't happen,
absolutely
right?
Not.
It doesn't happen in the reverse, which means it is political. And
it's totally political. And the answer for those of us who are small government advocates who wish to adhere to the founders' vision of liberty for the people is that fewer issues of import should be decided by the Supreme Court. They shouldn't be government issues at all. The idea that the Supreme Court is so important is true, but it's because every issue now seems to be or every behavior almost is either forbidden or mandatory. The sphere of human behavior that's fully free continues to shrink. And that means that it's ever important. Who makes the rules, right? But if there are fewer rules and more behavior that's open for freedom, then it's less important as to who decides things, because there's less to decide and there's less impact on our lives. And I think that is for conservatives and libertarians to really get behind, the notion that the sphere of our lives that is subject to government influence should be shrunk.
So what you're saying is that use of courts should be safe, rare, and legal. Is that?
And I mean it, unlike the people who've said that about other things, perhaps.
Absolutely. I can't think what you might be talking about there, Scott. Now, so the court packing, is it going to happen, though? Is there a realistic path?
It's not going to happen.
Okay. Why?
What
mechanisms are in place to stop it?
There's just not the political will to do it. Joe Biden kind of rejected the plan he commissioned to put forth, which I think was to mollify some of the more radical progressive.
Yeah, so that you're talking about he signed, I think it was an executive order to come up with a report that would suggest ways in which, I think anybody who knows how these government reports go, it will kind of say what Joe Biden wants it to say. That's
the funny thing is, it's like if you commissioned me to write a report about what new gun control law, how can we reduce gun violence in America, that I'm not going to suggest increasing gun control laws, because of the past experience you've had with my exposition of these ideas. So it's no mystery where things are going to come out for certain things. So yeah, it was no mystery. But then at the same time, he rejected the idea of going ahead with it. Now, you can say that he rejected it because of his thoughtful examination of our legal system and thinking that it's not the right course of action, or that the politics didn't support that move and they didn't want a loss on their hands. They want the fight and to lose the fight.
So where would that fight take place, though? Wouldn't that fight ultimately take place in the Supreme Court anyway?
No. That would be a Senate fight, maybe all of Congress. But the size of the Supreme Court is not set by our U.S. Constitution, and it has varied over the course of our history. And so if the president and the Congress, that's one of the ways they can actually exert significant influence on the court, is through the appointment process, not just by filling vacancies, but adding new members if they so desire. They would have to act in concert to do it. The president nominates justices for the Supreme Court, so it's not like with an uncooperative president, Congress could do it on its own. And the number of justices is authorized by Congress. And of course, I don't know that, except for Harlan Crow, many people could take that job and not get paid for it. And they authorize that they have the power of the purse. So in a very real sense, they authorize the judge to take the person to take that job by paying them.
Okay. And the most recent addition to the Supreme Court was Ketanji Brown Jackson. And she was afforded the seat due to the retirement of Justice Stephen Breyer. Now, that didn't upset the makeup. There were still 5 conservatives, 3 liberal, and Chief Justice John Roberts, who nobody really knows where he stands, which is probably a good thing, really, for a Chief Justice. But do we see any other retirements coming up over between now and the next election in 2024, or during the following term of presidency?
I think that I like your statement there about the Chief Justice, and I think you're right. It is probably a good thing that he's not firmly in one ideological camp in a country that is pretty deeply divided, and where these issues are very contentious, and the court deals with so many of them. Justice Roberts is not Chief Justice of the United States Supreme Court. He's Chief Justice of the United States of America. And I like that in some aspect, it's good that, that he can be the Chief Justice of all of us. We won't see any retirements or new justices, I believe. The liberals are young, and they're not going to retire anytime soon. I don't see Justice Kagan, who I think is like 65-ish. Lifespans are getting longer, and people are more vibrant into their older ages. So I would expect that we would only see, Supreme Court justices sitting for longer and longer on the bench. Justice Thomas is 75 years of age. He is, I think, the oldest sitting justice, and one would imagine that given his life, he would be loath to retire during a term of a president who would immediately replace him with someone who would take to his decisions with a crowbar, metaphorically, and break them apart. And a jackhammer, actually, is what I should have said. So that's what he could expect with any justice that President Biden might appoint, and that the current, Democrat leadership in the Senate would get through. So it's also a thing to consider for the next presidential election, meaning he's 75.
Something to think about. Scott, thanks ever so much for being with us today.
Thank you, Mark.
And that's all we have time for on today's Supreme Court Special Edition. I'd like to thank our fount of all legal knowledge, Mr. Scott D. Cosenza, Esquire, for his input today. And of course, I'd like to thank you, the audience, for taking the time to join us. William Howard Taft once said, "Presidents come and go, but the Supreme Court goes on forever." And in many ways, he was absolutely right in the scope of that. Decisions made by the highest court have the potential to shape the future in ways that no president really can. An idea that's best exemplified by the words of Teddy Roosevelt, who said, quote, "The president and Congress are all very well in their way. They can say what they think, but it rests with the Supreme Court to decide what they have really thought." Just something to think about there. Thanks for listening. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Don't get caught up in the media madness. Join our movement for free thinking, and free speech at libertynation.com. Publishing news and analysis 24/7 with original articles by our team of authors who tell it like it is. Join us each week for online TV shows, The Uprising Podcast, and Liberty Nation Radio. We believe in free thinking and free speech. We are libertynation.com.